Good morning.
Peace, peace.
All right, peace and love, everybody. Welcome to In God We Trust Academy podcast. Work session season 8, return of the master merchant. We got about 3 to 4 more minutes before we get started. All right, peace, love, and law. How everybody doing in here today? Y'all all right? Everybody good?
Yes, sir. How about yourself, brother?
Doing pretty good. Pretty good myself. All right, so I'm trying to have some technical difficulties here, so I have to do it this way so I can see any comments because yeah, it ain't showing on my side. But anyway, man, thanks for each and every last one of you guys. As always, welcome to In God We Trust Academy podcast and work session season 8. Good to be with y'all today. For sure, man. It's been a past few crazy last 7 to 8 days for me, ripping and running back and forth and a lot of stuff, but we still managed to get everything taken care of. Still had a great time for the conference, great fellowship with some great people as well. So appreciate everybody that came, appreciate everybody that made it back safely, and those of you that also participated online as well. If you missed that class, hey, what can I say? Um, I definitely would say that was a definitely the top tier class of the year as well. A lot of information has been dumped into that as well. So you guys enjoy that. Study it, you know, make it useful to you. Make it very useful to you. All right, so let's get started. We're not gonna waste no time. We're gonna hit this record button and we're gonna jump in to our session. Alrighty. In God We Trust Academy and the Return of the Master Merchant. We are in season 8, guys. Season 8, man. Very, 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 very proud to even be here to see we are in season 8 and all of the things that we have done. Give thanks to you for your participation and always showing up, your testimonies, etc., guys. And just thank to the Almighty to everything that has transpired to this very moment, allowing us to have the meeting of the minds, the conversations that and the work ethic and things that we are doing. And literally be able to touch others' lives. A lot of people like to say, "Oh, it's me." No, guys, it's you too. Your testimonies and just as people see you come in here, a lot of people got to see you grow and to who and what you are at this very moment. So again, it's all inspiring to each and every last one of us. A lot of you guys definitely inspire me for sure as well. So it's always a reciprocated energy here. So I'm very thankful for that as well, man. So everything that you guys hear from this point forward is educational, religious purposes only. Anybody seeking any legal advice, seek a legal advisor. It is my religious duty to speak my religious truth and experiences here with you guys today. So, with that being said, we got any testimonies today? Anybody with a testimony today?
I don't have a testimony, but I just wanted to say that I submitted my first motion ever at the end of last week, and I hope to have a testimony for you guys within 3 days. So I'm very excited about that. Thank you.
Absolutely. And I will say I was pretty impressed with the way you did. It was very well written, etc. So if this is your first time, that's why some people catch on quicker than others, especially if you're someone that just needs the ABC 1 2 3 to read and see what to do, how to do, when to do, where to do, and why to do. You give those people those things. Some people can take off running, and I feel like you definitely might be one of those people. So um, have faith in yourself in the process, and the information that you have taken in, and don't ever be discouraged about any of this.
Thank you. That means a lot.
Absolutely. Anybody else? Anybody else? Go ahead, Empress.
Okay, I got this. I got a testimony, right? So, you remember I was telling you the other day about my nephew with the vehicle.
Mm-hmm.
So I reached out to the president of the car dealership,
Right.
and I sent them an email or whatever, And from that email and the attachments that I sent them about the contract and things of that nature, the man was so nice about it. He was like, you know what, he was like, this contract is not how that was supposed to go. And he apologized for the experience being the way that it was, or whatever the case may be, because I told him that the car was the 40,000, and they put him in that contract for, just to give y'all a refresher, the contract that he would have been end up paying 76,000. Make a long story short, the guy, we went up there and they did a recontract with him, a new bill of sale, a new buyer's order with just the 40,000 that he paid, and they gave him a $5,000 refund check.
Man, that is beautiful. So now the car's bought all the way out, right?
Free and clear, all that, not nobody lien holder, no finance, and all that went out the window. Yep.
See,
I was so happy. I'm proud of myself. Yeah, listen, ooh, the
that's what
whiz
you
is coming
call
through.
being. That's what you call being a master merchant. That's what I'm saying. That's what this particular season is about. Literally, knowing your contracts, knowing your position, and truly understanding equity within itself, and knowing how to go about getting those things done. And yes, we got to hear that in real time because we just talked about this last week. So just to hear
Mm-hmm.
that has
Mm-hmm.
particularly happened, because I was definitely like, hey, resend all that crap, whatever they got
Yep,
to
you
do.
did. And I said, no, I'm gonna put up a fight, because I listen, since I've been learning law by itself, I just got this fire now where once I see that, okay, no, this not right, or due process, or whatever it might be, fraud, these criminal citation ticket things, it's a challenge for me. So once I do it, listen, I be doing it for people for free. I don't even care. I don't charge nobody, or whatever the case may be. So, with that being said, it's the testimony for me. So, I just wanted to come in here and give y'all my testimony. He got his car, he ain't have to pay no extra money. I yield.
Absolutely, and congratulations to you on that for sure. Um, that's amazing. I'm glad to hear that. Anybody else? All praise to the Almighty. Anybody else? All right, then. All right, so I would say, oh, my testimony for this year is the fact that we've had up to 75 testimonies from you guys. That's what my testimony is. 75 and counting. All right. I've been making sure that I keep some little tallies up, just about how many times and different times we hear testimonies, whether y'all hear it here or just through us receiving them through the emails and stuff like that. And right now that made 75. So I'm that's my testimony. Just from all of this work that we've been doing, all of these, the ebooks, all of the classes, all of the, and you guys are actually, and even just the consultations as well, or whatever it took. But just to be a part of that, and in your testimony as well, is that's beautiful. So I think that says a lot about what we do in here, and that we're able to, you know, uh, help that many situations, um, and actually win with those situations as well. So I just think that's amazing. So I really wanted to say that's my testimony for y'all. Somebody else just raised their hand. Who was it? Before I get started, you good? All right, then let's go. Then y'all ready to get started? All right. So we had the water edition. We did the earth edition, and the fire edition was with the lawful money class. And now we got the wind edition, which is the equitable procedure, right? And then the next one after this will be the spirits. They always say it's five. But you ever seen the movie Fifth Element? You know what they were talking about. But let's get into it, guys. Return of the Master Merchant, Wind Edition, Equitable Procedure. That's Joe. So, what is the missing link from the liability to enforceable defaults? A reoccurring misconception in civil and equitable practice is the belief that non-response alone creates enforceable default. When silence can carry legal consequence, it does so only when silence is procedurally established. Courts do not enforce conclusions drawn by a party; they enforce conditions proven on the record. The statement "they ignore me" reflects an interpretation of events, not a legally operative fact. Without documented service, a defined opportunity to cure, and the sworn evidence of non-response, silence remains an allegation rather than enforceable condition. So the Win Edition exists to correct this procedural gap for you guys, right? So liability, even when properly articulated, is a substantial condition, not an enforcement mechanism. The Earth Edition that we had establishes liability by identifying wrongful conduct, articulating the obligation, and placing the opposing party on formal notice. However, courts do not enforce liability in isolation. Judicial authority attaches only after the court can verify that the due process has been satisfied and that the opposing party has forfeited their right to contest the facts through inaction or failure to cure, and the Win Edition supplies the procedural proof necessary to convert established liability into enforceable posture, which is why, guys, there needs to be from you evidence. Because the whole point of us going to do declaratory judgments and things like that is because we're going to say they're in default of their performance and obligation. That tender by performance book is the real deal. If you tender something by performance and it requires mutual performance, mutual obligations from both parties, and that you cannot do something accurately until they give you the proper documentation, endorsements, all these type of different things to you to be able to perform yours, right? And then now this becomes a situation to where we're actually changing the narrative here. It's not about if you are in contract, a debtor, creditor, if you paid. It's you made tender, you performed your obligation. They did not perform their obligation. They defaulted. And when they default in that, now we get to go to court about them defaulting on the obligation. It's never about if you owe anymore or if you are a debtor. So this is why this is very, very important for us to truly understand. And this also goes back to the private administration class for some of you guys who took that. So this will kind of put you in the mind of that, but just give you a deeper understanding of that as well, right? So before a court will recognize the fault and give legal effect to it, the record must clearly demonstrate four elements: proper service of the operative instruments, a meaningful and reasonable opportunity to respond or cure, the absence of lawful rebuttal to the facts asserted, and sworn verification of non-response. These elements are not discretionary. If any missing, courts are compelled to reopen the controversy regardless of how strong the underlying claim may be. Excuse me. Regardless of how strong the underlying claim may be. Win Edition is structured to ensure that each of these elements is satisfied, documented, and authenticated before judicial involvement is sought. So if you're going to send something to someone, you got to make sure it's the correct address. If it says in your contracts that you are supposed to make certain communications to a certain specific place, send something here, then you have to make sure that you do that correctly, because that can harm you if you have not done proper service, because that's part of you fulfilling your side of the obligation in the contract, or if you performing that, just so that we're clear. All right. Default is not created by frustration, delay, or subjective belief. Default arises when a party, after receiving proper notice and being afforded an opportunity to respond, fails to rebut material facts with competent sworn evidence. This failure operates as procedural omission. Courts rely on affidavits and verified timelines to determine whether default exists. They do not infer default from correspondence alone. Okay? This is going to help transform silence into default by converting chronology into sworn fact, ensuring that non-response is no longer arguable but demonstrable. So that's what you want to be able is to just demonstrate exactly what you're doing. And remember, you have to be a great record keeper in this. If you are a master merchant, then you got records of any and all transactions, communications between your business. You're going to know everything about your contracts. Everything is documented, and you want to be that way. Because again, if there's an audit, if there's anything that you need to do, especially as far as proof, you got it on deck, right? And we want to make sure that you have it. So the Win Edition introduces the concept of operative facts, facts that stand not because they are persuasive, but because they were properly presented and left unrebutted. An operative fact is one that was served, noticed, supported by evidence, and authenticated by affidavit. Once facts reach this status, the court is not asked to weigh credibility or decide competing narratives. Instead, the court is asked to recognize the legal effect of those facts as they exist in the record. The shift is the foundation of declaratory relief. So you got to remember, now you're talking about the form. The form is you sent notice, you gave notice, you told of the harm, there was never any response, you sent a non-response, you gave an opportunity to cure, they defaulted. Now we have all our evidence to prove that they were properly served correctly, etc. And we can move to a declaratory relief based upon this default of obligation and performance from them. Right? Absolutely. So one of the most significant effects of perfected default is the narrative closure. Without default, opposing parties retain the procedural ability to reframe events, introduce defenses, new defenses, or dispute knowledge and intent. Once default is established, those avenues are foreclosed. Facts not rebutted when lawfully required and deemed omitted, and defenses not raised are deemed waived. So the Win Edition exists to lawfully close the narrative, not through argument or accusation, but through discipline procedure. And it does matter what you can prove. Remember, truth, proof, law, and relief. Okay, equity requires more than correctness. Okay, it requires fairness, and the Win Edition does not seek to trap or ambush the opposing party. Instead, it emphasizes clear notice, defined cure opportunities, and reasonable timelines. This approach preserves clean hands and demonstrates restraint. When default follows, despite these safeguards, it is the result of conscious inactions. Okay, not procedural surprise. Court sitting in equity gives significant weight to posture when determining whether the declaratory or injunctive relief is appropriate. Okay, the Fire Edition, if you get it or have it, it establishes good faith and tender. Earth Edition fixes liability and notice, and the Wind Edition completes the process by converting liability into an enforceable default. Without win, courts hesitate because, well, the procedure record remains incomplete. So the Win Edition, the court is no longer asked to determine what happened, but to declare the legal consequences of what has already been established by default. And that's what we want to lock them in, right? Okay, so this conversion is the precise function of the Win Edition and foundation upon which all subsequent equitable remedies rest. Okay, that is where we want them. So what is the role of due process in equity? What is the role of due process? So due process is not a technicality. It is the threshold condition for the lawful exercise of power in both law and equity. No obligation may be enforced, no liability may attach, and no remedy may issue unless the affected party has first been given notice and a meaningful opportunity to respond. This principle is universal across civil procedure, administrative law, and equitable jurisdiction. Courts do not inquire into the wisdom of enforcement until they are satisfied that due process has been honored. Okay? So the Win Edition is constructed around this foundation rule, not as a defensive posture, but as an affirmative requirement for enforceability. So there's two elements of due process: notice and opportunity. You always have to have a right to be heard, a right to defend, okay, a right to face your accuser, a right to see any and all evidence that is placed against you, a right to, well, if they're going to make a claim, then you have the right to see what is that claim. It's part of it. Due process consists of two inseparable elements: notice and opportunity to be heard. Notice must be sufficient to inform the recipient of the nature of the claim, the obligation asserted, and the consequences of non-response. Opportunity must be real, not illusionary. It requires adequate time, clear instructions, and a genuine ability to respond or cure. A notice that is vague, rushed, or procedurally deficient cannot support default. Therefore, insist on clarity, specificity, and reasonableness. Ensure that any Subsequent default arises from constant inaction rather than procedural deficiency. So equity does not relax due process requirements, right? It heightens them. While courts of law often operate on rigid timelines and technical compliance, equity looks to fairness, conscience, and balance. For this reason, equitable remedies are available only to those who have exceeded, not merely met, minimum procedural standards. So the WIN methodology here is deliberately provides more notice, more clarity, and more opportunity to cure than most institutional actions provide. This surplus of process is not weakness. It is the mechanism by which clean hands are preserved and judicial skepticism is neutralized, right? So again, equity is going to be fair, guys. So that's the reason why I say, if, for instance, if you do a tender by performance and you performed, and I can see, and you have to remove, as soon as I say tender, you don't have to automatically say payment. When it says that the note is legal tender, means that it's a legal offer of the performance for all debts, public and private, meaning that this specific dollar will settle the matter, okay? By obligation of who? The United States. So you got to truly understand what obligation and performances bring us into. So if we do a tender by performance to settle a matter here, and we require certain things to be done, then these things have to be done. If they default in doing or not presenting that, then we send a notice of liability. We're letting them know this is the liability that you're carrying for not responding. All right? You see what I'm saying? And then it comes into, okay, now we're giving you an opportunity to cure here. All right? And now, after the opportunity to cure, they haven't cured, they automatically fall into default. By the time they hit into default, we're automatically going. Because remember, we're sending the notice of liability, et cetera, as we already have the declaratory judgment claim ready. Other than a few other timelines that you can put into it by default, et cetera. But once we already got that ready, then we're ready to go. So it might be a declaratory judgment in certain places. We might go to a civil claim in federal if it relates to public officials as well, because it has to deal with a federal question, deals with the Constitution and things of that nature. But my whole entire point is we change the situation. They have to deal with what you're bringing them to court about. So it's based upon them defaulting in performance of their obligation, right? It's not about if, oh, you made a payment, because they're going to say, hey, he did his obligation, he tendered, you didn't perform, you didn't give the things that were asked for so they can make an accurate, finished completeness of their performance. You didn't do it. And since you didn't do it, well, this is discharged because it really becomes a state of a dishonor. So keep that in mind, guys. Keep that in mind. So this process is lawful precisely because it aligns with and offers or passes the procedural protections embedded in civil rules and constitutional doctrine. Government agency creditors and institutional plaintiffs frequently initiate enforcement actions with minimum notice and compressed timelines. By contrast, this edition requires documented service, defined cure periods, clear articulation of obligations, and final opportunities to respond before any judicial relief is sought. Courts recognize and respect this posture because it mirrors the core purpose of due process, preventing surprise, coercion, and arbitrary enforcement, right? So properly executed due process does more than protect the opposing party. I need some water. My mouth getting dry. Does more than protect the opposing party. It protects the claimant when notice and opportunity to cure are documented and reasonable. The claimant is insulated from allegations of bad faith, sharp practice, or procedural abuse. Okay? So this edition is designed to create a record that demonstrates patience, fairness, and restraint. And this record becomes decisive when equitable remedies are requested, as court sitting in equity scrutinize the conduct of the moving party as closely as the conduct of the defaulting parties. So you must have clean hands, and this requires that a party seeking equitable relief must have acted fairly, honestly, and without manipulation. Okay, so the WIN edition here What this is going to do is make sure that you are fully disciplined in all of your procedure. You got to make sure. And you want to make sure that you cover everything, because the more you do, the more paper, the more you have proof, the more it's going to all be in your favor. And it's not going to be so many things in your gaps within your claim in order for you to do these things. So you make sure you want to cover those elements. As I always tell you, truth, proof, law, and relief, right? So by serving clear notices, allowing meaningful time to cure, and refraining from premature litigation, the claimant demonstrates compliance with equitable conscience. When default occurs, despite these safeguards, the record reflects not opportunism, but necessity, okay? This process significantly strengthens requests for a declaratory judgment, injunction, and accounting, because why? It's all laid out for you. There's nothing that they can do. And that's the reason why I say, if you got these things, guys, they're going to operate in your favor. They're not going to want to keep trying to argue and go back and forth with you. They don't want to take the risk of exposure and things of that nature, right? Okay. So this process is lawful precisely because it aligns with and often surpasses the procedural protections embedded in civil society, guys. Do keep that in mind. So the maxim is, he who seeks equity must do equity. It is not abstract philosophy. It is an unenforceable rule. In the context of the Wynn edition, doing equity means providing notice sufficient to inform, cure sufficient to correct, and time sufficient to respond. It all means refraining from enforcement until these conditions are satisfied. When these duties are fulfilled, equity obligates the court to act when the opposing party refuses to engage. And the reason why you want to fully carry this through, because you want to make it about them defaulting. They defaulted. Everybody, I don't care who we dealing with, make them default. I don't care if it's the IRS, whoever. And equity is going to definitely make sure that you win, right? Absolutely. So the refusal to respond after such process is not a procedural accident. It is failure of conscience that equity is designed to remedy. Default cannot exist without due process. Any attempt to enforce default without demonstrating notice and opportunity will fail regardless of underlying merits. So this addition assures that default, when it occurs, is unimpeachable because it arises only after due process has been fully satisfied. And this is the moment where equity transforms silence into admission and action into waiver, not by interference, by operation of law. So what am I saying? What are we saying here? Again, once you get them into default, see, the only thing they could come to do to court now is just come perform. That's the reason why I say and this is how you flip the narrative. Let's say that you got somebody that's going to take you to court because you owe something, whatever the case may be. All right. Now, for the past 2 seasons, 6 and 7, we spoke on, and the end of season 5, we were saying, do a motion for production and things like that. That can be granted or denied by the actual judge. Now, I'm not saying we still know how to handle that and make sure that it's enforced because we can use the higher court. But if we want to take that away from him, then we can do a tender by performance. And we telling the judge right then and there, I tender by performance and I stand ready to make payments, okay? But I need the opposing party to perform their obligation to make a complete, accurate performance, to give a complete, accurate performance, because I cannot give it without the original note. I cannot give it without certified copies under penalty and perjury, declaring that this is the chain of title, declaring that the statement, the bill of statement that you sent, etc., is under penalty and perjury. There's nothing clarifying the accuracy of this, and I can't do a complete performance until these things are given to me. Now, if they don't, the securitization, any insurance, all right, any discounts of it being sold, that means we get to see all the 1099s, anything that's involved, right? We get to see all taxation papers, whatever. We want to see it, all right? Now, if they don't come and perform and do what they're supposed to do, they're going to lose. Do everybody understand that? Can y'all truly see what we're taking away from them?
Yes.
Yes.
They're going to lose because they should have performed already. And the only thing the judge is going to say, well, they tendered by performance. You didn't perform your obligation. They even tried to they gave you an opportunity to cure. You defaulted in the situation. So, are you ready? Do you have those things here ready today? And they're going to say, no, we do not. Then that's when you just move for a default judgment because they don't got it. Ain't no continuances, none of that shit. You either ready or not. They're not ready. They're not going to be ready. That's the same way that you have to say when you go into these courts, because you're gonna catch them off surprise when they come in there, and the only thing they put on there was a copy of a contract. There's no chain of title or anything like that. It's just a copy of a contract. They're gonna put the ledger in that shows that you might have made payments here, and then they're gonna show where you defaulted and then make payments, and then the judge is gonna be ready for you to come in and perform. Ain't that how they do y'all? Yes or no?
Yep.
That's how they do you, right? So the only thing you can do now is just that come in and tender by performance. You see what I'm saying? You tender by performance. Now, when you come in and say you stand ready to tender by performance, now they have to. They have to come in and perform. So now, only things you're gonna say is, "Well, I can't make a complete performance here today, Judge, because I don't see the chain of title. I don't see any certified copies under penalty and perjury declaring that these are accurate, that they actually hold the notes, or I don't see that the note is being held in some form of trust. I have a right to all of this because of the equitable contribution I have been given here, and they have an obligation to perform for me. So I can't make a complete performance without these things." That goes for court too. You see what I'm saying? How do you plead? Oh, okay, I'm here to plead by tender by performance. Yeah, you can do traffic tickets the same way. You can do child support the same way. Doesn't matter what it is, because we're ready to tender our performance. And the performance that they're looking for is for you to make the account whole. And if they want the account to be made whole, they need to make you whole first. Oh, man, I hope y'all hear what I'm saying.
I do.
Man.
Flip the script
Loud
on
and
'em.
clear, loud and clear.
What you say, Brother Terry?
Flip the script on them. Use their tactic and to your benefit. You flip what they be asking you for, that you flip it back around so you get the same thing they claim they have. In the proof.
Yeah, and you have to know there is a plea of tender. It does exist. Absolutely. So I stand ready today to tender by performance. And there's a mutual obligation here that has to be done, and their performance has to be taken into consideration. If they don't do it, they default, then there is no jurisdiction here for the court today. So that's the way that you do. All right, so providing more due process than legally required has strategic value. It deprives the opposing party of procedural defenses, narrows the issues before the court, and frames the controversy as one of the refusal rather than dispute. Courts are far more willing to grant declaratory and equitable relief when the record shows that enforcement was the last resort, not the first. All right, Win Edition is built on this principle, using due process not as a hurdle, but as a leverage. So that also gives us the right to do an abatement. Abatement is saying the same thing. Hey, man, listen, we need to abate this situation basically because I can't perform until you perform. And I need these things to be performed by you so I can give a complete performance without error. Let that sink in for a minute. What are the performances we're looking for? They have to establish jurisdiction. They have to let you know the nature of the case. They have to let you know all of that. for the record. All right. They also have to establish the surety here. They also have to establish also that they are qualified to operate in whole court today. Right? They have to on the record. Mm-hmm. That is very, very important. So due process is not a box to be checked. It is the condition precedent to enforceable equity. Notice and opportunity are the mechanism by which fairness is demonstrated and default is legitimized. The when addition exceeds due process requirements to ensure that when equity is invoked, the court is compelled to act. The principle governs every procedural step that actually follows, right? So actual controversy when the court can step in. The court does not exist to supervise negotiation, monitor correspondence, or referee private disputes that have not yet crystallized into a justiciable issue. Judicial power is invoked only when an actual controversy exists. Once that is concrete, ripe, and capable of resolution through a judicial declaration. That's why I say all disputes create controversy, right? So now the Win Edition is designed to move a matter from private process into judicial competence by creating the precise conditions under which a court is authorized to act without reopening disputed facts or entertaining premature enforcement requests. So a declaratory judgment action is often misunderstood as a request for approval or validation. In reality, it is a procedural vehicle by which a court is asked to declare the legal status of existing rights, duties, or obligation. The party seeking declaratory relief is not asking the court to create liability, determine fault, or compel performance in the first instance. Instead, the court is asked to recognize the legal consequences that have already arisen and through notice, opportunity, and default. This distinction is central to the addition because as it prevents the court from reframing the matter as contested lawsuit rather than a status declaration. You see what I'm saying? So now it ain't about if you owe, you the creditor, you all of that. It's you defaulted upon your obligation, and that's what we're here to determine here based upon rights, duty, and obligations. Yeah. I hope you're paying attention. Declaratory judgment operates on status. The court declares what is not what should be. Okay? After the Win Edition has been properly executed, the relevant facts are no longer in dispute because they have been presented, served, and left unrebutted. The role of the court is therefore limited to declaring the legal effect of those facts. This limitation is intentional and strategic. By focusing on status, the declaratory action avoids evidentiary battles and prevents the opposing party from relitigating facts that were procedurally admitted through default. Now, when we say status, it ain't the status what y'all thinking, okay? We're just talking about your right, your interests, the duties, the obligations that are implied within the declaratory judgment. Okay? So let me make sure I clarify that before somebody say, oh, well, so you got to correct your status. No, we're not talking about in that way. Okay? So, an actual controversy arises not from disagreement over facts, but from a refusal to acknowledge their legal effect. After proper notice and opportunity to cure have expired without response, the controversy is no longer whether the underlying conduct occurred. The controversy is whether the law recognizes the consequences of that conduct and the default that followed. So this edition frames the refusal as the justiciable issue, positioning the court to intervene without exceeding its constitutional and procedural limits, because no state can impair the obligations of contracts as well, right? They can't impair them, right? Got to make sure we're moving in equity. So the distinction between dispute and controversy: dispute involves contested facts or competing narrative. A controversy involves unresolved legal consequences arising from established facts. The Win Edition is designed to eliminate dispute before court involvement by ensuring that facts are either admitted through response or admitted through non-response. What remains is controversy, a live question of legal status that requires judicial declaration. This distinction is critical as courts are reluctant to entertain disputes prematurely, but are obligated to resolve controversies once properly presented. So if they don't perform their obligation, it creates a controversy. The dispute is we didn't have what we needed. And yeah, in order for us to do it, you need to give this to us. It becomes a controversy when they don't perform their obligations. Understood?
Yes.
Yes. Hey, Eric. So basically, this goes for any case, any court case, right? I just want to make sure
We
I got
talking
that.
about every situations though, not just court. We talking about everything. Any and
Gotcha.
all
Thank you.
things. So now default functions as the trigger that converts private process into judicial competence. Without default, the court risks intervening in an incomplete or evolving matter. With default, the court is presented with a closed factual record and defied legal question. This ensures that the default is not assumed but demonstrated through affidavits and verified timelines. Once default is established, the court role is no longer discretionary. It is declared the rights and obligations that flow from the record. And that's the reason why they affidavits to say something like, you signed a contract on this day. You agreed to do such and such. They sent you a notice on this day. You did not pay. They sent you another notice on this day. You did not pay. And then they send you a notice of default, etc. And you defaulted out, and now they're here today at the court here to foreclose on the matter, right? Now you got to go in there, and they're gonna come at you like, well, did you sign this contract? By law, yes, you did. That automatically means you're afforded the obligation. But you have to break it down into equity and say, hey, I'm here to tender by performance today. I'm not here to talk about the facts. We're not here to talk about the actual law and the facts itself or the form. We're gonna deal with what? Substance. Make them deal with the substance of it. Make the conscious man come out. See, that's how you remove that robe and everything off of them pretty much, and you make the conscious man, the individual, appear to you. Because now they have to deal with the substance of the situation. I'm here and stand ready to tender by performance today. Oh, he just made a tender. Damn, he fulfilled his obligation. And now you're making your request to make an accurate performance. These are the things that you're going to need to complete your performance. You're not saying you're not going to pay, so that's not going to default you. You're not saying that you're not going to do any of that. So that's why I say any letters that they're sending you, anybody, no matter who it is, that's sending you saying that you owe something, tender by performance and watch them default. Take their ass to court, you're going to win. If they take you to court, you got all the evidence still right here for you guys. Yeah. And then when you come to court, you say, hey, I was ready. I made tender by performance on this day. Here's the opportunity that I gave them, the opportunity to cure, et cetera. They defaulted in their obligation, and I still stand ready here today, Judge, to tender by performance. And then they're going to look at them and say, hey, you got that? And they're going to be like, no, we don't have any of that. Can we get a continuance? And you say, no, I have a right to a speedy trial. If the evidence and stuff is not here today to prosecute the matter, then there is no subject matter. There's no personal jurisdiction. I'm going to move this case to be dismissed immediately. That's equity. Yeah, let that soak in for a minute. That's equity. Okay? That's equity. So, with that being said, at the declaratory judgment stage, the opposing party continued silence or denial is legally irrelevant. The operative issue is their refusal to recognize the consequences of their own procedural default. So, this frames the refusal as the controversy requiring resolution. The court is not asked to punish the opposing party or compel immediate performance, but to declare the status of the obligation and the effect of non-response, and this approach aligns with both equitable principles and judicial restraint. So only thing we're doing, a declaratory judgment is basically they're going to let them know, hey, this is what happens. They're actually right in their situation here, and you might want to settle whatever matter is going on with them, because if they go and make this a civil claim against you, it's going to hold weight, and they can take this declaratory judgment and place it in that civil claim as well. Mm. Yeah, I know, right? Yeah, I know. So, declaratory judgment serves a protective function by clarifying rights before coercive enforcement is sought. It allows the court to define legal landscape without ordering damages, execution, or sanctions. Okay, the Win Edition uses declaratory relief as the first judicial step precisely because it limits the scope and reduces resistance. Once rights and obligations are declared, subsequent remedies, whether legal or equitable, proceed from a settled foundation. And that's what you want. Okay. So, in this edition, it is procedural bridge between private process and judicial declaration. The fire establishes good faith, the earth establishes liability, and the wind establishes default. Together, they produce a record that presents the court with a single narrow task and declare the legal status arising from the record. The bridge prevents the court from reopening the facts and ensuring the judicial action is grounded in due process rather than the conjecture itself. Man, we women. We are winning. We winning, guys. Somebody just heard what I said. And I guarantee you they in a situation, and I guarantee you within less than a month, I'm gonna hear from them and say, hey man, I heard what you said in that class that day, and I went in there and I did it. I did tender my performance and I told them I was ready to perform. And I asked for these specific things to be given to me so I can make a complete performance, and they didn't have it. And I moved for the court to be the case to be dismissed, etc. And yeah, I won. It's gonna happen that way. And somewhat of light of that. Trust me, it happens all the time. Somebody sit here and listen to what I said. They take it. They actually go do it. They win. And yeah, it's gonna happen. And anytime I tell y'all there's some testimonies coming, it's coming. I know it. It's just because it's too easy. They don't want to expose their hand, because if once they expose themselves, guys, then that's going to lead to another lawsuit. It's going to also lead to others being able to do a class action on them. It's going to lead to all different type of stuff, right? And here's the thing, guys. See, you can ask for the securitization audit. You can ask to know, these specific things. Who is actually the true holder? Is the trust holding? And what's the name of the trust, etc. You have the right to know all of that. And see here's the other thing. The reason why is because, well, if you go look up, like I showed you on Bank of America, they have a securitization process for credit cards and other things like that, right? Well, just pull it out. And they can't deny that they don't do it. If you got a credit card from them, they do it. They telling you they do it. So now you need to be understand you are an equitable contributor into that, and that you have equitable rights in that. If they sold it and made a profit off of it at any given time, you have a right and interest in that, right? You can see about them in that, in equity. Yeah, see, that's what equity says. So, service is the gatekeeper of remedies. Service is not a clerical step. It is the act that confers jurisdiction. Until a party is properly served, no court has the authority to bind them. No obligation can be enforced against them, and no default can lawfully arise. Jurisdiction does not attach because a claim exists, nor because liability is alleged, but because notice has been delivered in a manner recognized by law. Courts are bound to examine service before reaching any other issue, and when the service is defective, all subsequent proceedings are avoidable regardless of the merits of the case. So that means that if you send them notice of liability and all this stuff to the wrong people, right? See what I'm saying? If you send that to the wrong people and then they have proof to say, well, hey, in the contract it says that we said send all these correspondence here. They sent it over here. They're going to say they wasn't properly served. And since they wasn't properly served according to the contract itself as well, then yeah, that is a violation, guys. And they're going to say that the case is going to be dismissed because they were never given the opportunity to hear. It was not properly notified or given the opportunity to hear the matter. Now, that's the problem. So jurisdiction requires knowledge, and service is the lawful mechanism by which knowledge is imputed. A court cannot presume that a party knows of a claim, obligation, or demand unless the record demonstrates lawful delivery. Service transforms a private assertion into a public enforceable matter by placing the opposing party within the court's authority. Without proof of service, a court has no power to declare rights, impose obligation, or recognize default. And this is why service is examined before liability, damages, or remedy. Okay. Knowledge is a legal condition, not a subjective belief. Service establishes knowledge by operation of law, regardless of whether the recipient chooses to read, respond, or acknowledge the document. Once service is completed in lawful manner, the recipient is deemed to know the contents of the instrument served. Courts do not inquire into actual understanding. They rely on proof of delivery. The principle protects the integrity of judicial process by preventing parties from avoiding responsibility through willful ignorance or silence. So due process cannot exist without service. Notice and opportunity to respond are meaningless if the notice is never lawfully delivered. Service satisfies the notice component of due process and triggers the recipient obligations to act. When service is proper, the burden shifts to the receiving party to respond, rebut, or cure. Failure to act after service is not a procedural accident. It is a conscious forfeiture of the right to be heard. See? Yeah, they waived it. Okay? Service as a foundation of estoppel. So estoppel arises from the reliance on a condition that another party has allowed to stand. Service is the event that creates the reliance. Once a party is served and fails to respond within the allotted time, they are stopped from later denying knowledge, surprise, or lack of opportunity. Courts rely heavily on proof of service when applying estoppel doctrines because service demonstrates that the party had every chance to protect their interests and chose not to do so. That's what we want to present in front of them for not performing their obligation. They had every chance to protect their interests. But since they didn't perform, they didn't do so, it results into a default. It also means the refusal is discharged as well. So, do understand that. You can consider it fully discharged. And all obligations at this particular moment are settled. Okay? So, waiver is the intentional relinquishment of known rights. Service applies the known element. When a party is served and remains silent, the law treats that silence as a waiver of defenses that could have been asserted at the stage. This is not punitive. It is procedural. Courts cannot permit parties to sit on their rights indefinitely while the opposing party remains in uncertainty. Service initiates the timeline that converts silence into waiver. The most frequent cause of dismissal in otherwise valid cases is not lack of merit, but inadequate proof of service. Courts require clear, documented evidence showing when, how, and whom service was made. Informal delivery, undocumented mailings, or assumptions of receipt are insufficient. Even when service actually occurred, failure to prove it with admissible documentation deprives the court of jurisdiction and nullifies all subsequent steps. So the strong service proof is precise, contemporaneous, and verifiable. It identifies the method of service and the date, time of delivery, the address of recipient, and the instrument served. It is supported by objective evidence such as postal records, right? Delivery confirmations, affidavits of service, or process server declaration. Courts rely on these documents, not recollections or assertions, when determining whether service was effective. So know that. Every later procedural step, opportunity to cure, default, estoppel, and declaratory relief depends on service. If service fails, the record collapses. If service is strong, the record becomes self-authenticating. Courts routinely overlook substantive disputes when service is airtight because jurisdiction has already been established. And for this reason, service is not merely the beginning of a case. It is the anchor that holds the entire proceeding in place. And you have to know that. No service, no jurisdiction. No jurisdiction, no remedy. Keep that in mind. Okay? So, what are the lawful methods of service? Well, guys, of course, certified mail, return receipt. Service must comply with the recognized civil procedures. So, it could be return receipt. You could do personal service. You can do process server with the sheriff. You can do commercial courier with delivery confirmation, email service where lawfully permitted, especially if they agree to be contacted within these particular places. Service on corporations and registered agencies as well must be served through their designated registered agents or officers as specified by statute. So keep that in mind. You have to serve the registered agent or any officer specified by statute as well. Service on government agencies and public bodies. Well, most of the time, the agency is subject to special rules that vary by jurisdiction, and these rules often require service on specific officials, offices, or legal departments and may mandate multiple copies or specific methods of delivery. Failure to follow these rules precisely can defeat service, even when actual notice exists. So when serving a government entity, strict adherence to statutory service requirement is essential, and proof of service must reflect compliance with every procedural elements. So make sure that your service gain is on tight, right? So refusal, avoidance, and return mail. Let's talk about this part, because this matters. Refusal of service does not defeat notice. It strengthens it. When a party actively refuses delivery of properly addressed and lawfully sent documents, the refusal itself becomes evident that notice was attempted and intentionally avoided. Courts recognize that due process does not require acceptance of notice, only a reasonable opportunity to receive it. A recipient cannot nullify service by declining to open the door, refusing to sign, or rejecting certified mail when the method is used is authorized and properly executed. So, return mail marked refused or unclaimed or unable to deliver does not automatically invalidate service. Courts examine the surrounding circumstances, including whether the address used was correct, whether delivery was attempted in accordance with postal or courier procedures, and whether additional reasonable efforts were made. When these conditions are satisfied, return mail often supports constructive notice rather than defeating service. The key is not physical receipt of the document, but the reasonableness of the attempt and the reliability of the actual delivery method. Okay. Carrying the service record after return mail. When mail is returned, the proper response is not to abandon service, but to carry the record. Carrying may include resending the documents using a different authorized method, attempting personal service, or serving through a registered agent where applicable. Each subsequent attempt should be documented with equal or greater precision. Courts view multiple reasonable attempts favorably as they demonstrate diligence and good faith. A courier service record often becomes stronger than a single successful delivery because it shows intentional avoidance rather than procedural error. Now, what I'm going to say about this is this: like, if you got contracts with people and you put your name and address, etc., on these particular things and said that this is your mailing address or residential place, then they have a right to serve you there. Even if you're not there, they can continue to serve you there. And if they served you there, the only thing they can do is say they just got a green card saying that it was received or whatever the case may be, or you were properly served at that particular place. And once they do that and they show it to the address, well, guys, that's all they can go off of. So they can really consider you to be served. And if you don't show up to court, they can literally go on and default the situation, which is what happens with a lot of people, right? So you got to be careful of those type of things too, right? Be mindful. Be very mindful. So when mail is returned, the proper response is not to abandon service, but to carry the record. Carrying may include resending the documents using different authorized methods. Make sure you do so. Multiple service attempts serve a strategic and evidentiary purpose. They demonstrate persistence, reasonableness, and respect for due process. Courts are more inclined to recognize service and default when the record reflects repeated and verified efforts to provide notice. Multiple attempts reduce the credibility of claims of service or lack of knowledge and support findings of waiver and estoppel. The objective is not harassment, but certainty. So, also, constructive notice arises when a party, through their own conduct, prevents actual notice despite reasonable efforts by the serving party. This principle is procedural, not theoretical. Courts apply constructive notice when service was attempted in compliance with recognized methods and the recipient actions cause delivery to fail. Constructive notice allows the court to impute knowledge and proceed without requiring further futile attempts. Proper documentation of attempt is essential for this doctrine to apply. So not only can you use this yourself, but just know they use this against you. Okay? Just so y'all know that. Okay? So be mindful of this. Don't think just because you, oh man, I don't live there, that ain't gonna always work. Especially then, that's the reason why if you show up there, boom. You have to be able to say, I haven't lived at this particular place since such and such, such and such. All of my, it's been updated. Even especially if you can prove there's an updated address, etc. But if it's a debt collector, they in fault anyway. It ain't your fault. You don't owe them anything to update anything with them. So, but if it's somebody that you already dealing with from that particular situation, then and usually they get the sheriff to serve you. That way, if the sheriff serves you, But if the sheriff try to serve you, and it said attempt failed, and you were never properly served in that particular thing as well, then yeah, they could that case can be dismissed for that reason too. Do know that. Okay. So avoidance is distinguishable from non-delivery. Avoidance involves deliberate conduct designed to evade service, such as refusing mail, instructing others not to accept documents, or repeatedly being unavailable at known addresses. Courts are attentive to patterns of avoidance and may treat such conduct as evidence of bad faith. Documented avoidance requires objective facts, not accusation. Dates, time, addresses, and delivery. Outcomes speak louder than conclusions. Law is going to deal with that, but equity is going to say that the party owes an obligation to update their information. And I'm just telling you, if that was me on the other side and I couldn't, then I do have these addresses, et cetera. And then we always give you an opportunity to update any address, because most people do. They'll send you documents and say, hey, to update any personal information, such and such, such and such. If they keep giving that opportunity, they can make that, and they can use that against you. Y'all do know that, right? That is part of acting in good faith. And it shows that you acted in bad faith by never updating that particular information. Not saying everybody gonna think like this, like I am right now, but if you run into somebody that do, just know it can be used against you. So that's the reason why sometimes it's not, if you can deal with the proper service first, deal with the proper service first. But if you can't, then you should step in right into tender by performance, abatement, motion to dismiss for lack of jurisdiction, something of that nature, right? So just know, be ready. You should have more than one option. Be ready. Service records should be factual, neutral, and precise. Avoid characterizations such as fraud, bad faith, or conspiracy. Instead, document observable events, delivery attempts, refusal, return envelopes, tracking results. Neutral language preserves credibility and prevents the court from dismissing the record as argumentative. The goal is to allow evidence to demonstrate avoidance without editorial commentary, right? So a clean service timeline consolidates all attempts to the chronological record. Each attempt should be supported by documentation such as postal tracking, courier logs, or service affidavits. This timeline becomes a central exhibit in any motion or declaratory action and allows the court to see at a glance and that service was reasonable, diligent, and sufficient. A clear timeline often resolves a service dispute without further litigation. So service is not an endless obligation. Once reasonable efforts have been made and documented, the law does not require continued attempts in the face of avoidance. At that point, constructive notice may be relied upon and the procedural record may proceed to default. Knowing when to stop is as important as knowing how to start, as excessive attempts can appear unreasonable or coercive as well. All right. So, hope y'all learned something. Y'all learned something today?
Yeah.
All the time.
Let's stop. We're gonna stop here at chapter 7. We're gonna talk about a few things. So I'm finna go. I gotta give me some water though. So let me go get some water right quick, and then we'll jump into our questions and stuff. Hold on. right, let's go. All right, Oba, what's up?
Yes, sir. Yes, sir. I was peeping what you're saying. Thank you very much, brother. I always appreciate you very
Love you too,
much.
fam.
I noticed in a few phones you refer to it as the tender by performance, and in a couple different places I've heard them refer to it as a conditional
It's
acceptance
not the
or a
same.
qualified written.
It's
It's not
not.
the same.
It's not the same.
Okay, because what they would do is that they would use that conditional acceptance or qualified written request, and they would issue a special deposit with it, and it would have some of those terms you're talking about, the performance terms with the special deposit. And I think that they will use that to create the situation that allows kind of what you're saying with the tender by performance.
Yeah,
But you're
but
saying that it's a different.
conditional acceptance. Listen to the word of what you're saying.
Oh yeah, definitely. I've also heard of
You're
the
not
same kind of
making. You're
theory.
not making a tender. You're just saying I'm going to conditionally accept this upon their whatever reasons. I'm saying
Oh,
I hereby tender by performance.
okay, and yeah, and that was the second the process or the form that I heard about this qualified win request. They combined it with that performance, and they just had it as a special deposit. They didn't really talk much about it. That's why you're what you're educating is so powerful because they really didn't talk about that part of it, which I'm starting to understand was really the power in it was the tender by performance.
Yeah, because a conditional acceptance usually come with the manipulation or trying to change the contract or something of that nature, or they're trying to get them to accept something. You get what I'm saying? But that's why I said
Completely.
if you do a tender by performance with the coupon itself identifies the obligation that must be performed by both parties. You want them to clarify the accuracy of the statement and the accuracy of them being able to have the authority that to collect a debt or to call up on a claim or those type of things to see the securitization audit. Like you don't know, like they could have sold the note and made some money, and there's equity there for you. You don't know, but if they are in securitization, that is a great very possibility. And you don't want to miss making that claim on something in equity for you, and they consider you waiving it because it was never fully disclosed. But you have to understand it's your right to know that. See, they don't tell us that the fact that you got this social security number and the fact that you're going to operate in these contracts, you are saying that you are an expert and master merchant in contracts and in commerce. That's what you're saying. And that's why I said it's really dangerous to send our children out here just saying, like, hey, you got to have some check stubs, this and that to go get a what's that, go get a car. They don't know nothing about consumer law. They don't understand the Fair Debt Collection Practices Act. They don't understand RESPA when it comes to real estate and stuff like that, right? Like, no, we just out here. And that takes away everything because you're expected to know. You're expected to know equity. You're expected to know that you do have equity and rights and interest in these things. And if you don't say anything, communication is the one rule in business or anything. And if it's not expressed, then you leave open for any presumptions that wants to be made. So
I completely agree.
that's why it's important. All right, Ms. Rez Seeley, what's up?
Hi there, Eric. So I have to admit that I really don't understand this whole equity thing. I really don't. I heard you say it's about fairness, but do you go into the courtroom and you file a lawsuit against the lender, quote unquote lender? Do you go in there and formally change it into a court of equity?
No, you go do a declaratory judgment. That's equity. You go do an injunction. That's equity. You want something to stop, you want an injunction, you want to stop something, then you go do that. You can go do abatements for other type of situations. You got writs of quo warrantos, those type of things. All of those are things of equity, right?
Okay, so that's understood by the court when you do those things then for equity.
Of course.
Okay. And then when you say moving in equity, that's what moving is. Your motions show you're going towards in with equity.
Absolutely. That's why I said I hereby tender by performance. That's equity.
Okay. Okay. All right. That helps. Thanks.
Yeah. Or if you move the court to dismiss something that's something that should be done or ought to be done, Based upon the lack of evidence, that's fairness, that's equity. Law and equity are there together at all times. Where law fails, equity arises for that situation. Law says that law is going to fail in the fact that you have a contract, you signed it, you owe, etc. Equity says that you tender by performance, right? You did fulfill your obligation. Equity also says now that you have a right to full accounting and disclosure of any and all things, because equity said in the contract that the creditor is subject to all claims of the debtor as well. So they have to perform their obligations. If they don't perform their obligations, well, equity allows us to go to get a declaratory judgment or an injunction, or I can just go sue for breach of contract because you didn't fulfill your side of the obligations. Equity is going to take care of that. Equity is going to see that you was an equitable contributor. And that's the reason why you move the court in equity. See, equity, you can go in there and say, like I say, you're here to tender by performance today, but you can't complete an accurate performance until they complete their obligations, their mutual obligations, which is their transparency with you. And if they don't give you those things, then how can you make an, and see, that's what equity is going to see. That's what the judge is going to see. So you're not refusing to make a payment. You're not refusing that this contract, you didn't create any form of, you didn't go in or make an argument. You went in there to settle a matter, but this is what you need to settle the matter.
So is it best that we hold off on using the coupon and performing until after we've asked all their questions, put them through the administrative process?
I'm going to tender by performance now. Did you take the class this weekend?
No, I wasn't there.
Yeah, you ain't got to tender by performance. You go, but my point is like it's just what it is. Like I ask you guys all the time, equity says that there has to be, all right, equity declares accuracy. Equity declares efficiency, sufficiency as well. So now, if a corporation sends you something, like I don't know, let's say, what's the name of your cell phone carrier?
Spectrum.
So you with Spectrum. So I could type a bill up right now that looks exactly like Spectrum, use their address, everything, because I could definitely use their address. It ain't shit gonna happen but them send it to you. So I can do all of that, stamp it, all of that, send you a letter. I'm gonna send you a bill saying that you owe, and I want you to pay at this particular address. If you don't pay attention, you could easily open that up, send that bill specifically where I said send it to. And if you know what I know about elderly people, especially my mom is she's still the type to tear off the coupon, send it where exactly what the address say send it at, attach it, etc. She could do that. And she would send that money directly to me. You didn't have any accuracy of anybody going under penalty of perjury declaring that this statement is coming directly from this particular company. It's authenticated of its accuracy. You see what I'm saying?
Yeah.
Equity says you deserve that right to know. So if it's not there, then how can you make an accurate performance?
So if you've been paying them for years.
Hold on. We ain't gonna go back. We ain't going back about that. We talking about right now. I want you to answer my question. How are you going to make an accurate performance?
You're going to ask them questions.
I know that, but I'm asking you, like, you can't. So really, everybody's been out here you're performing based off of a belief. It's not, nobody went under penalty of perjury. Nobody declared anything to you about the bills that you're receiving. It's not stated. It's not signed off by anybody. It's not signed off by a notary from a representative of that particular corporation. Nothing. So you deserve that accuracy. It's not a chain of title in there saying that this particular have the right to ask. It's not a certified copy of the note or any of that. You see what I'm saying? And since that's not present, then I can't make an accurate performance. And until that happens, then here we go.
So the request for validation would be the tender by performance?
It's tender by performance though. Like your tender is the offer. You're offering your performance for a
Okay,
mutual
I got you.
performance. So what's your performance that you're offering?
I'm offering to perform on the presentment
Right. Exactly.
if they can verify it, validate it.
Exactly. That's exactly what we're saying. Do you understand that now, Mr. Seeley?
The way I understand what you all are saying is because nobody is sworn to anything of the truth of what I'm receiving, that I don't need to do anything until I get that.
You just
That's what I,
you not doing anything is silence and will lead to default. Tender by
right.
performance is you actually fulfilling your obligation. You made tender.
Okay.
So
I ask the questions of them. I send back and ask all these questions, and they default. So I do the administrative process through them, but I haven't actually performed with a coupon.
well,
So that, I guess,
the coupon is just to identify the obligation. I don't want to make that special. So let me say that. It's just to identify the obligation. You can use the whole damn bill, the invoice, whatever. But I said the coupon because it's easier to tear off. It's easy to identify the actual obligation, the account, loan number, etc. Everything's on there. It asks how much do you want to fulfill. You can put in the amount of the coupon or say other. You can put the whole full amount of the principal and say, I'm ready to make tender, but I need you to show this. And now you have to understand if they show dishonor to the extent of tender of performance was made, then if they refuse, don't do, etc., then it is what? Discharge to the fullest extent of which tender was made.
okay, I get that part. Okay.
All right.
So when I go into the courtroom and prove what I've done, I can pretty much stand on, look, here are all my records. Here's all the things that were done properly. I'm just here for my equity, my fairness, right?
I mean, that's what you're saying, but it's by default that you're here by default because they
Right.
defaulted. So you want to know that they defaulted on their obligation. You want all rights and interests to be determined in declaratory judgment, or you can just do I'm saying declaratory judgment, but you can just go to get an injunction based on this.
Okay. Okay. So those are some of the key things I need to study and learn about. Okay, that helps a lot.
Yes.
Great. Yeah. Okay.
Someone says, but they don't have the right, but they don't, but don't they have the right not to accept it? Yeah, you can not accept it. Go ahead. I tendered. And if you choose not to accept, it's going to be discharged as well because the obligation was to make tender. Yeah, to tender, to perform, to perform. So here I am telling you, I stand ready to tender. Here is me showing good faith. I'm going to send a coupon in you to you and let you know what the obligation that I'm ready to perform. Here it goes. But I cannot give a complete, accurate performance until you do so. You refuse it if you want to. I'm gonna smile. Refuse that shit. I will be so happy. Act like you don't want to do it, okay? Or
But
send.
Eric, is it important that when you uh do that quote unquote, performance, by that you have endorsed it properly, or is that the fullness of me tendering, which I'm not going to do that until they prove to me all these other things.
I mean, the only thing you got to do is just tender by performance and sign it. I mean, it ain't nothing
Yeah.
to say. And you can put pay to the order of United States Treasury and then put the company name on there if that makes you feel safe to do so. But at the end of the day, I'm only tendering by performance.
Okay. Gotcha.
I
Okay.
stand
Thanks.
ready. I make an offer. And that's all that matters. See, equity is going to say that you did. Equity is if you have already done it. So once you make the tender by performance, it's just as if you paid the actual money too.
Can I say something like quick? If
Yeah.
they go back and study the UCC3, this gonna help you understand this a little bit more. That's why studying UCC is so important with us, as far as help us understand these type of things also.
Facts. because Article 3, UCC, was it 3-603?
Yeah, that's it.
Yep, by which tender was made. So you made that to the fullest extent. They don't perform. And let's say that they can respond, but you also got to understand what vague responses are too. They can respond and not say nothing, not send you a damn thing. They could also send you just the ledger of the account and don't send the rest of it. That still does not help you make an accurate decision. So you got to know that just because they sent you something. I don't give a damn if the attorney start trying to make a threat. If they still haven't sent you what you asked for, they are in default. Do not let these folks discourage you. They have to give you full transparency because the fact that you've done these things, they owe you a right. Same thing with court. Court is the same situation. You got a traffic ticket. Okay, great. Well, I'm standing ready here today to tender my performance, meaning that, okay, I can do whatever needs to be done. If you're going to say if it's relation to a track, something that's old, like child support or something, whatever the case may be, but they have to perform these specific things, right? In order for you to make an accurate performance, right? That's one. Then also when it comes to, traffic tickets and stuff, things like that, that's what abatements are for. Abatement is saying that, okay, this has to stop until you guys give us everything to make sure that this court is competent and has the jurisdiction to continue this court. So right now, this is going to be an estoppel. So I abate this matter. Why? Because you don't have A, B, C, D, E, F, G. You see what I'm saying? You haven't given me the nature of the nature of the nature of the claim, etc. Right? All of these things have not been proven on the record. I've asked, I declared, whatever the case may be. So if you find an error in it already because of lack of due process, these things have to be done in that matter because now they're going to fall into a form of default because they haven't proven anything on the record, which leads to dismissal of the case. It's going to do it every single time. That's just like the one of my clients on here. We had a consultation about his situation. I think he even said it on here, but he really went to somebody's right to travel class, and they had him traveling with a American Coalition diplomat tag, and so he was pulled over, and they tried to charge him with forgery. But the truth is, forgery of what? It says American Coalition. It does not say the United States of America, and it not don't say it was issued by the Department of Justice, etc. So now they have to show proof of that, and since they can't show proof of that, right? He can't perform. He can't perform what they're asking, so he can abate that matter, or he can do a motion to dismiss for lack of personal matter and subject matter jurisdiction because the charge doesn't match with what they're trying to say. It's not forgery. Forgery does not exist in this matter. There's no cause of action to grant relief here today. Case dismissed. Do y'all understand what I'm saying?
Yes.
Yeah.
Yes, sir.
Yep.
And I know they were, kind of worried about the situation, but that's why I tell y'all,
Yes.
don't panic. And if you out here doing these negotiable instruments and stuff, I keep telling y'all, put on there void where prohibited by law. That will save your ass from a forgery charge. Why? Because they have to prove willful intent to defraud. By you saying void where prohibited by law is in good faith, saying if this is wrong, then it's void. You don't have to act on it. I'm not attempting to defraud you. I'm just doing this based off knowledge of what I think to the best of my ability. And if it's wrong, void it. Now, if they try to bring one of those charges against you, guess what happens? It removes willful intent because that's what it means to in forgery, willful intent to defraud. They got to prove willful intent. But once that's on there and it's been written on the statement, etc., then, well, it takes away the willful intent. Case got to be dismissed because it can't be forgery anymore.
Straight game.
Ignorance of the law is inexcusable. I told you not to act upon it. You did it anyway. So you can't say I deceived you or whatever the case may be. It was open. It was written to you. You truly understood and you acted on your own provisions from that point forward. Do y'all hear what I'm saying?
Yep.
Yep.
Absolutely.
So
Yes,
all y'all
sir.
out here doing that tax stuff, void where prohibited by law, I'll put that on every tax document I ever send in to these folks. That way, if they do act on it, well, I told you the void where prohibited by law. You can't come back and say I did something wrong when I just specifically told you to void it. You didn't. Ignorance of the law is inexcusable. You did that on your own. Not me, not upon my cognizance at all. I operate in good faith.
And still willing to perform.
You see what I'm saying? See, now you get it. Sade, what's up?
Hey, Eric. I just wanted to know, like, how many classes did I miss before I could catch up with what you're talking about now with the equity and stuff? Like, I know you just said there was a class this past weekend.
Let's see. We didn't done about what, 4, 5 ebooks?
And dealing with equity because I got the last class. I just want to make sure I can because I'm familiar with equity when you were speaking on it a while ago. I just want to make sure I can catch up as quickly as possible because I was trying to do that for my case. I just wasn't sure how to go about the tender, tender payment or whatever you just said about the last class that you just had. So I wanted to be able to do it right. But when you're saying bring equity, do it in equity, you would be doing an injunction or an abatement. But if it's a case that's already going, is I got it transferred to appeals court, and
That's
we
equity.
didn't. We got yeah, that's equity. So we got shut down though. They dismissed it due to procedural errors. Do it was for what was that called? It was for it not having a affidavit and an affidavit waiver of the fee because my husband is incarcerated or whatever. So we were trying to figure out if we would do an independent action in equity to the trial court and in the appeals court because it's not his merits weren't dismissed. It was just a procedural defect. But there was a case law, Howard versus somebody, where they said they're just waiting on you to cure it. But they said that, oh, you get dismissed procedurally, and who was it? The Supreme Court doesn't reject it if it's not done. So we're kind of in limbo to see if we can do equity in all courts. I know that, but I don't know if we should put in an injunction or just put in the independent action and equity. So I'm trying to figure that out right now. That's why I'm trying to see which class and all
Well,
that
the
to get.
situation is
So,
this: if you exhaust all remedies in these particular courts, then yes, you can go to equitable remedies such as injunction. You can even get a declaratory judgment on the particular situation as well. But again, it wasn't. So you filed the claim. Is what you're saying?
uh, yeah, and the civil complaint. Well, basically, the civil complaint. We went so far with that, the judge ended up dismissing it under a 12B6 or whatever. So then that's when we moved it to appeals. We got it into appeals, but they automatically dismissed it because they said, well, the third panel, no, excuse me, the three panel judges had said it was dismissed due to procedural issues of not having paying a fee and doing the affidavit of cases he's done before. But the whole thing of it was the judge when he dismissed it in the trial court, he dismissed it off of the like I said the 12B6, but he didn't
So,
answer any of the motions or
so
anything
let me
like that we still have pending.
so let me
Uh,
ask you this though: like, was it with prejudice or without?
um, from the trial court, it was with prejudice, but the appeals court, it wasn't. It wasn't with prejudice at all.
So, but the appellate court is agreeing with the lower court. Is what I'm saying. So if it
No,
was with prejudice, they did it with prejudice based upon the cause of action that you brought it under, which was what?
the cause of action was fraud upon the court, false imprisonment, and all of that. But the lower court, I mean, the appeals court didn't put prejudice with it. They didn't dismiss it with prejudice. The
I
lower
know,
trial court did.
I know,
Huh?
but they said they agreed with the lower court, right?
No, they didn't say that.
Well, what
They
did they
just said
say?
it was for due to procedural issues. They said it's getting dismissed due to the statute that was upheld by the Supreme Court that you have to pay the fee, or turn in an affidavit of indigency, and you have to show the
Oh.
previous cases in the
So
5 years. You get what I
basically,
mean?
you just need to redo your appeal. Is what you're saying.
Right. That's what I'm getting at. Yeah. So how would I go about doing that though?
You just need to redo it. The only thing the situation was is that you didn't deal with the procedure or the filing fee, so they didn't even look at your case yet. They just judged it
Yeah.
off
Yeah.
of
Pretty
due
much.
process
Yep.
of trying to enter it into their arena. So you just need to make sure you go back and do that again, but do it immediately.
So I can do that. So I can do that by just re-putting everything back in and adding that to it, or just resend it out, or do I do a reconsideration?
I mean, you
Like
just
how do
need
I
to
do
do
that?
whatever that they said. Go read what they said you didn't do. Go do it. Refile everything, and you straight.
Okay, that I got you. Okay, but I still want to get those classes you was talking about. So you said you did like 4 ebooks
Well,
already total.
we are in. Let's see, we did November, December, so we got 2
Okay.
months. If you do that, you'll get the gold member, whatever. So that'll give you everything in
Okay.
both this month and last month.
Everything. Okay, bet. Okay, I'll go do that. Thank you.
All right, you're welcome.
All right.
All right, Brand, Mr. Robert.
Hey, Eric, you touched on the declaratory judgment, and it's my understanding if one has a pre-existing, let's say like an administrative default, dishonor, consent to judgment claim, coupled with a perfected commercial lien, basically a foreign judgment, that one could, rather than filing suit, open up a court docket, file a petition for declaratory judgment, plus maybe a writ of execution, writ of attachment for enforcement of said claim for remedy. Would you agree with that? Is that
Yeah, you
feasible?
can do it because it's because see, what's gonna happen is they're gonna determine the rights and et cetera in the situation, and that's what you want. And it'll help the other party see that, well, this is what's gonna happen if you go and literally go make this a civil claim. And you can also use declaratory judgment as well as a form of evidence to back you to get that civil claim.
Now, this can be done ex parte, right? Because they've already agreed, they've already consented to judgment. By virtue of their
declaratory judgment, they're still gonna be given the opportunity to be heard.
So would they have to be served then if you're
you still gotta serve them.
Okay, I guess I was under the misconception that you didn't have to do that since they've already consented
But
to
my
judgment.
point is you already got it. See, you're trying to make it about something else. You got to understand they have to come for what you are speaking on by default. So you're right in what you're saying. And they do still have a right, because like no matter what, the only thing the judge is gonna say, are you ready? Do you have whatever that you're asking for, or they should have done or performed, or whatever the case may be? Do they have it to perform today? And if not, this is the situation.
Right. Now, if there's diversity and answer to federal question and the monetary damages exceed $75,000, then the appropriate venue would be federal
Correct.
district court, right?
Correct.
Okay. The last thing I would ask is, when everybody kind of looks at the AI chatbots. When I query like the AI chatbot about the petition for declaratory judgment for like an administrative default judgment using, a private commercial administrative process, using a notary presentment, notary default, all that. It says that, of course, it's very dismissive about that and the courts don't recognize it. But it's still contract law, and I don't see how a court could be dismissive. What do you think about that?
Be dismissive about what, though? Specific.
Oh, the fact that you have basically a foreign judgment that you're seeking,
I mean, it is a default. Like, that's what your situation is. You have your own personal foreign judgment of the matter because you got them in default, and this is what you have judged upon the matter. So you can enter that in. That's the reason why you can offer your foreign judgment as a proposed order.
Right. So I'm just seeking kind of like domestication or ratification of a pre-existing foreign judgment, judicial ratification.
Yeah, so you can make them come by default of what you are stating that was done. See, that's the thing about the declaratory judgment is that they have to come specifically about what you want to talk about.
Right.
You see what I'm saying?
Mm-hmm.
So It ain't nothing about what they want to. It's what you brought them in there for and what you have on record to prove of the situation, et cetera. They have to answer to that specifically.
Eric, do any of your, I've got several of your ebooks. Do any of those in particular address the declaratory judgment specifically? I know you kind of touched on it here. Obviously, I'd have to go through.
Done it. I mean, the only thing I would say is the master of lawsuit class and stuff like that speaks on it, because even the declaratory judgment is done the same way. You still got to have, the right elements, the, jurisdiction and stuff like that, your claim, really truth, proof, law, and relief in the whole entire matter. So, it's still, I haven't done one specifically just directly on declaratory judgment, but master of lawsuit is all the same.
Maybe you could do that. That would be a worthwhile class if you're interested. Anyway, thanks for the insights. Appreciate it.
All right, appreciate you. Sam, what's up?
Hi, Eric. Sorry, I'm a little sick, so it's not super easy to talk. But this whole class today got me thinking. About 6 months ago, I had someone who thought like I was who called a welfare check on me, and so the police, they came to my house and they took me to the hospital against my will. They like handcuffed me, and now I'm getting bills and statements from the hospital for like treatment and like being there that I didn't even want in the first place. And the thing is, I know I shouldn't have ignored them because it's not acting in honor, but I just wasn't exactly sure how to deal with them. And it's been like 6 months too. So if I do default on that soon, or if I get taken to court for that soon, I was wondering if I do the whole um, plea by it's escaping me, by a tender of performance. What is the things I need to request from the
I'm gonna let you answer that, because you got to know
mhm.
that for yourself. If I make a claim on you right now, what you gonna ask me for?
I guess proof that I owe you. But the thing is, technically, I do because I did take those treatments. I never wanted them in the
See,
first
see,
place. I
see,
didn't.
see, see. You not you
Mhm.
trying to go off and think. I want you to answer my
Okay,
question. What you going
I
to?
guess.
I want you to specify the documentations of what you would need in order for you to accurately perform what I'm asking to making a claim on you. So what you gonna ask me for?
Excuse me. Well, I guess an accounting that is accurate. And uh, well, I
Accounting
know
of
you'd
what?
mentioned that there was three things that I needed to ask for in the class earlier. I wasn't able to
See, you
catch
going away.
them.
You going away from the question. I'm asking
Okay,
you
okay.
because I'm saying,
Yeah.
like, right now, if somebody like,
Hmm.
because like the point is this. What I'm trying to say to you is,
Hmm.
y'all need to listen very carefully. Somebody can
Hmm.
do y'all like this right now, just out the blue. Send you something in the mail. Send it to you two or three times so they get you through default. Make sure they gave you a time enough to answer these specific things, and then they can create a contract that look like a signature of yours that they lifted. Say that you signed this contract. They can do an affidavit stating by the dates of the contract you signed these things. They could create a ledger account showing that you were obligated to pay. You didn't pay. You defaulted, and you're here to for judgment today. What are you going to do?
Um. Well, can you prove that you gave me clear notice? I guess. I don't. Um.
That's all you want me to prove is prove I gave you clear notice. That's easy. I can show proof where I sent you certified mail to your certain address to you.
Well, I never signed for
So now
anything.
you got to pay me.
I'm gonna think about
Um.
performance.
You said, no, I'm saying I sent you what you
hmm.
had. You said, all I got to have proof is that I sent you something in the mail to show that you were properly served, whether by for court or whether that I sent you to, the billing statement and stuff like that with invoices, whatever. You were properly served. So we got that out the way. So now you got to pay me. Anything else you want?
Well, did I sign anything? Was there any
Yep, you
contract?
signed this contract right here. Here's a copy of it. Here you go. What else you need?
Um.
I got you. And we ain't even did business before, but I got you paying me in court right now.
Anybody?
It's escaping.
You
I'm
got a
sorry.
lifeline. Do you need some help? You need some counseling?
Please,
You want some
please.
counsel?
Yes,
Yo,
please.
where's the
Anybody
original
want to give him
contract?
some counsel?
You need the original document that you signed, the original contract.
I don't got that.
Wedding signature.
Okay.
I got certified copies, Judge. I don't have that.
Well, I need it to be presented under penalty and perjury that that is the original document that I signed, or else you have to dismiss it because you can't prove that I signed that. I don't have any recollection of doing business with you.
Tender
Mm.
bar performance. I'm here to tender. If
The
you can prove that
plaintiff
I signed that,
the plaintiff is now going to ask for a continuance so that I can talk with the defendant to try to settle this matter outside the court.
No, I don't want to. I just want to go ahead and dismiss this.
I have a right to speedy trial, right? Isn't that what you said earlier? There's no continuance because I have a right to speedy trial. How
But
can I settle this matter today?
what did she say that made me have to answer that way?
She said that she has no recollection of signing anything, so she needs the original document
Well, I
with
got
her
certified
signature.
copies. That's good enough. What she
Well,
said was is that will you go under penalty and perjury and declaring these things as accurate and true? And the hell no, I'm not. So with that being said, you know, I'm gonna ask for a continuance to see if you understand what's gonna be said on that. If you don't do that, then I'm gonna move to have this case dismissed. That I'm going to as a plaintiff, I'm going to dismiss this case.
Mm-hmm. Okay, thank you guys. I appreciate it.
now that makes sense.
And there was no injured party either, was there, Eric?
It is
But his
until you start. It
contract.
is until you tell me I got to go under penalty of perjury. I'm getting out the way. Hell no, there ain't no injured party no more.
That silenced them from being the injured party.
Technically, he the injured party
Well,
because they came and took him on the welfare check without his permission, without his say so,
Well, that
and
is
treated
true.
On
him.
That is true.
presumption.
So basically, he's supposed to do a counterclaim on that situation as well. But I'm just trying to get y'all to see what I'm trying to open your eyes up to. Like undergoing under penalty of perjury is it's serious. If you go get a business right now and you try to do anything, the first thing they're gonna say is, "Oh, this is not notarized. This is not declared under penalty and perjury of something or notarized or anything of that nature." If they don't see that, that shit don't exist. A bank ain't finna take nothing from no corporation that's not notarized by the with the officer signature on it as well. They ain't finna do it. So if the banks act that way, you should act that way too. Why the hell you gonna allow them to send you some shit they ain't notarized? You don't know where it come from. You don't know. And like I said, I can get your address right now, put your name on it, everything, and I can send a letter to somebody else right now, and it'll look like it came directly from you. Who's gonna stop it? They still gonna send the mail. They gonna deliver the freaking mail, right? Right? Are they not?
Correct.
I mean, hell, you had a pen pal's name. That's not even a real a person that's so to say at that time. So you got to really think about it. You can just write anything. I could use somebody's address right now, all the way in LA, and I can send something. I mean, you can do that. If you got an postal address in some other city, state, you can use that address to send certain things off, right? It's the same thing. It's not changing. So y'all got to realize we need verification of everything. Everything needs to be verified in business. If you're not willing to go under the penalty and perjury, if you're not willing to place yourself, you see what I'm saying, at risk under penalty and perjury, then none of this is real. That's why the court always respects those who go under penalty and perjury. An affidavit is not writing affidavit at the top of the title. An affidavit is anything under penalty and perjury. Y'all do understand that, right?
I do now.
Yes.
So that's why you want to make sure these things are done accurately and in the right way. Mr. Biggs, what's up?
Peace, peace.
I had testimony. I just didn't get to share it
Damn,
because
bro, you just got you just left from up here. How you get a testimony that fast?
no, actually coming there was the testimony. I just wanted y'all to know
Oh,
that
okay. Talk to me.
it's yeah, it's one thing to do this on the web, and it's a whole nother to actually come and feel the brother live and be with the people. And I just wanted to thank you again for such a good time and man, just being a genuine guy. So y'all make sure y'all make it there. And the workshop was fire. If you don't have it, make sure you get it because that pay by tender, that book right there. I'm about halfway done with it. So yeah, thank you, bro.
Oh yeah, no problem. Vincent, what's up?
Okay, I was talking to you earlier that I got the summary judgment for an amount, and I'm gonna do the writ of mandamus or whatever to vacate the judgment because they keep denying it. But I'm hearing you say this about the tender by performance, and I wonder if I should go ahead and do that on it anyway, and then once they won't produce all this stuff, I go back and do a declaratory judgment, and how would that affect the summary judgment if I haven't got a hearing date before then?
What do you I know y'all be thinking my mind is
Yeah, 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 yeah.
a
I
terabyte,
got
but my memory, boy. So what's your situation?
oh, I got suit against my LLC and me, or whatever in Chancery
Hmm.
Court in Tennessee, Nashville, Davidson County, or whatever.
Hmm.
And they gave a summary judgment, but remember I said they violated due process. He was
Right.
late with discovery. I got proof of that. Emails from him and me showing these things. He even filed
Yeah,
a affidavit
you
into
saying,
the
well,
he filed an affidavit in the case
yeah.
as well, and he
Mr.
can't do that
Biggs,
being
hold on one second, bro.
counsel.
Mr.
Oh,
Biggs,
so
mute out for me. Go ahead, bro.
He can't do that being counsel and witness or whatever. That violates the code of professional conduct. I forgot the exact number. So all these things are the violation of due process. But I have to get back in there to vacate the summary judgment that they gave because I was actually there the day that they gave the summary. The day for the
Right,
summary
right.
judgment. I missed court that day. But they keep denying it or whatever. She keep
And what?
denying the motion, but it's been filed, and you said like they gotta once it's been filed, she gotta hear it. She gotta
Right.
hear a correctly filed motion. That's due violation of due process as well. Correct.
Well, if she denied it, then that is making sure that they denied it to not have a hearing on it or whatever the case may be. But that's cool. You preserve the record. Now you set for the appeal. You want to make sure that you do the notice of appeal and all of that type of stuff immediately up after the judgment has been clarified.
No, I did a notice of appeal months before we even got this far when she had denied something else. But to get to the end of it, I'm supposed to have a right to be heard for to vacate the summary judgment. Correct.
Well, you
That's
do
why you
have
telling me to do the writ of mandamus.
right. They do have a right to. You do have a right to be heard, but it's only if they grant it, then there's a hearing. If they deny it, then they're not going to allow it to be a hearing. That's my point.
Oh,
So,
but then so
but you ain't losing nothing. You just exhausted all remedies. Now, you can't do an appeal to the court has already made a full judgment on the case and try and basically closing out the case. That's when you do an appeal after the final judgment has been made. So when the final judgment has been made, you exhausted all your remedies. You got everything. You're going to deal with the violation of due process and the errors and procedures. All right, that you were just speaking on. Right. That's
yeah.
what you're going to use in the appeal.
Okay, but you see,
No.
I was banking on the writ of mandamus, so now I don't know if I missed the time for the appeal.
Well, just go and see.
Yeah.
And because it's really 20, it's usually 21, 30 some days. And that's why I tell people to go. And it's after the last thing that has been dealt with. So if they did that, you did the motion vacate, like you need to go ahead and do the appeal now.
No, I know I did this last month. She denied it last month, but I just got the mail was slow or whatever. I just got it out the mail last week.
Well,
Seeing
you
that she
just need to
denied
tell them. You just need to tell them that you didn't receive certain type of mail to whatever particular day. Because one thing I do know is they
Because they
don't.
definitely ain't certified. They didn't send it certified or
That's
none
what
of
I was
that.
about to say.
Yeah,
That's what I was about to say.
definitely didn't send it certified.
All right.
Okay, okay. Well, I'm working on the. I just got the mess and the pills and all that. I gotta get that down, man, so I can try to get that out sometime this week.
Yeah, work
Top
on
of it.
that ASAP. But yeah, you'll get it done. Absolutely. All right, we up to 22K likes on TikTok, man. Appreciate you guys, all the hearts, all the goats, all the roses, everything that you guys always do on here. Your participation. If you're new to us, we do this every Monday and Wednesdays. Mondays 11 a.m. Central Time. Wednesdays 6 p.m. Central Time. This is called work sessions. If you want to know how to join work sessions, send us an email, admin@ingodwetrustacademy.org. Again, admin@ingodwetrustacademy.org, and ask to join work sessions. And we'll make sure that you get the link and be able to get in. All right, Mrs. Seeley, you're the last one. I got to get up out of here. Got to do some traveling today.
Okay, thank you, Eric. I'm looking on your website, but I don't see the tender by performance ebook.
Yeah, it's not up there. It was only specifically for the lawful money class. I told y'all it was gonna be exclusive for sure, and I knew this type of situation was gonna happen. But just give me some time because we still trying to sort out some things, and we'll make it available soon one day for sure.
Oh, great. Okay, then. Thank you. Have a great day.
All righty. All right, family. If you had to rate today's class, what would you rate it?
Infinity.
Definitely a 10.
I hope y'all learned something from this. We got a lot more to cover. We just on chapter 7. There's 21 chapters in this particular ebook, but I do definitely want to start leaving more time open for us to ask questions and dialogue as well. Somebody asked that we start doing role play. I got some things coming in the future. A lot of my classes and lessons are going to be done through short film. So we're finna start getting into that where we're creating short films for, situations so people can actually see how those things work together, and you can see it in real time for yourself through short film. So it's gonna take some work, gonna take a lot of time to put in, but I'm going to literally figure out how to do it. That's something that I wanted to step into this year, is to doing that type of thing so you guys can actually see it as a scenario for yourself. I know people are visual. Some people can see vision just by hearing, and some people actually have to actually see it, and I truly understand both. But hey, whatever it takes, whatever it takes to show you and how to apply, etc. I'm always enjoy doing this. I love doing this. I'm always gonna do this. It's not nobody that's going to stop me from doing this. What I will say is this, though, guys, is listen, I'm not exempt from a mistake. I'm not exempt from losing a case. I'm not exempt from shit happening to me, as well as others that's teaching are not either. The only thing we're doing is sharing with you the best information we can. Don't look at us like we some type of god in this, because we're not. The point is though, I'm not afraid to step out in the water and go first to see what's what. If I take a hit, I take a hit. Oh well, I get back up, I start pushing. So there's people out here that's willing to do that, and you see that, then hey, just especially if you ain't doing shit, you not finna try, or you not finna whatever the case may be. Just kind of sit on the sideline and sit back, man. Don't get caught up in all this old raggedy whatever that goes on left and right. I see it, but I don't participate in it. You know what I'm saying? So, I see it, and trust me, there's people that's gonna say people scam, or who's scamming and who ain't scamming. I've been called a scammer before, but as I told you, if you're gonna say I'm scamming, then go put that shit on Discovery, and let's see how far you get if you bad enough. You know, that's how I feel, and we can go through it. But I don't really get into all of that. And I kind of watch. Trust me, I watch and see everything. I see what people do. I see how a lot of people move, jump from one cage side to the other side. And I'm just telling y'all, man, be careful. Be careful who you surround yourself with. Be careful what you put yourself with, associate yourself with. It's going to reflect on you whether you know it or not. But you can't stop nobody from messing with nobody. People gonna still rock with people no matter what, because their perception is not your perception, and the way that they dealt with or reciprocation of energy with that person is not the same that it happened with you. So you're not going to stop it. You're not going to stop it. Like people will send me a YouTube thing about this woman talking about me. Man, I listen, and I could go in on this woman, but there's no reason to, because I know you were here to ask me for help. And we told you we wasn't going to based upon what you were asking, and that's cool. So you walk away and you talk about us. But guess what? That was 3 years ago. We still pushing. You ain't stopped nothing. We grew. Right? So I just, man, remain in honor. People gonna test you. People gonna talk shit. People gonna try you. They're gonna do it to you, family. I promise you. One is because they're gonna be mad because you're doing it. You're actually getting success from it. They don't like that. And the fact that they didn't, they will call something a scam because, like we said, if you go to court and you did something, oh, I did this, and that, and it didn't right, they scam me. No, you still got an appeal. Sometimes these judges and these people know that, okay, you don't know how to make an appeal. You could be totally right and still can't go through these courts correctly because procedure matters, due process matters. You can't run away from it. I'm telling you. So don't let these people discourage you. Don't let none of this shake you, rock you, whatever the case may be, man. Keep your nose down in these books and then stay out the mess, yo. We all trying to learn. Everybody's not going to get it right. I ain't going to get it right every single damn time. But if I do miss some or whatever, then I'm definitely going to check it. I'm going to perfect it because I told y'all I hate to lose. I don't like losing. I'm a sore loser at that. I'm going to find a way to win. I won't sleep till I win. And that's just me. And I think that's the greatest part about rocking with me because, shoot, we ain't stopping. Ain't no stopping. Yeah. You can go search my name and you'll see some crazy ass cases that I filed trying to do stuff. Shit, but that ain't mean I was out here trying to scam somebody or whatever. It's just shit. I just jumped out here trying to figure out. And now that I have, boy. Mm. But it took me to file some bullshit. So I'm just telling you, I learned. That's the way I learn. I'm not telling you to learn that way, but that's how I end up because I couldn't pay $3,000-$4,000 a class and shit like that. I couldn't get that to people. I was like, man, I'm just gonna go. I'm trying to hear what y'all talking about. Take as much as you give me, and I'm gonna go research and buy and pay for the rest as much as possible as I can. Other than that, I'm out the way. What's up, Mr. Smith?
I just want to say this there. Excuse me. Depending on what state you in, what county, you got to remember you got human beings sits on the bench, and you ask God for favors. You might know everything, done everything possible right. They sometimes they found something because they don't want to let that go through, and they'll try to get you on a procedure thing. Because I'm dealing with that in the case I got going on in Georgia. We've been fighting on this case for about 6.5 months. And every time we go do something, do it the correct way, the judge found another way to try to keep us from going through. When I'm dealing with a foreclosure through a hard money loan.
Right.
So my basic concern is with y'all is you're gonna win some, you're gonna lose some, like Eric say, but if you understanding what to do and how to file the correct papers, is you still have a human being on that bench. So you guys think about that.
Yep.
And I have learned from this case. I have won a lot of foreclosure cases. But the reason I'm sharing it with y'all, don't get discouraged. Learn from it, go back and study. And Eric had given us a lot of material to study and perfect. But before you go try to do something yourself, make sure you understand all the court procedures, the remedies, and everything, and research it before you start doing your levels. Eric give us a template, but depending on where you at, you still got to kind of make it adhere to the course that you're going in. So keep that in mind. Don't get discouraged. Every time you go in a courtroom or do something, you're gonna learn, and it helps you to be able to keep your faith going forth to help somebody else.
Absolutely.
Yeah.
That's a fact. Absolutely, man, for real. And that's just that. And take that for what it's worth for somebody that actually be in the trenches, getting testimonies and all of that. And you hear him saying like it takes 6 months. I heard him say they was working on something for a couple of years or whatever. But it's to keep pushing. And just because they tell you no, don't mean that there's not a yes waiting on you. The yes is waiting on you, but you got to go back and perfect. You got to go do this. Sometimes we be so excited to file something, to do something, and then we just want to pile it all on them at one time, and then you can't really do that. And that's something that Ricardo was learning, that there's a procedure, there's this. You don't want to get too ahead of yourself or filing something that'll mess you up ahead of time or whatever. So it takes patience, it takes time. But man, don't discredit somebody out here that's out here doing the work. And I'm saying, I'm speaking. I don't care who it is. I respect everybody that's teaching, whoever doing whatever, whoever getting results, however you doing it. Is all love. I don't got no hate for nobody. I don't, I ain't got the time to even think like that about you. So my point is, but I'm just telling the others out here that's jumping from one person to the other to the et cetera, et cetera. Really, it's on you. You keep jumping from everybody, but when are you going to take the time to sit down for yourself and digest all of this information instead of looking for, a quickie? I mean, that's what you're looking for. You're looking for a quickie. So, hey, you looking for a quickie, you're going to get quickie results. Sometimes quickies just bullshit. So, hey, don't expect the best out of certain things if you're not ready to go all the way through it. And I always tell you that's the reason why I teach the way I teach is because I want you to actually know the why, the how, the when, the where. Not here. Take the coupon, tender by performance, send it in, and send a letter of notice, a liability, etc. And then that's it. That's all I tell you. I didn't tell you exactly how to take that, either use it in equity or we can use it by law and go by statute, etc. Right? It's just ways of doing stuff. But we're here to learn it all and learn it every single type of way. I just wanted to say that because a lot of people asking me about who this person is and what I think about this person. I don't think nothing about none of them, except for the fact that they teaching, they doing the best they can. If they scam somebody or whatever the case may be, or if you feel like you got scammed, I still feel like that's on you. Read the shit your damn self. Know what's going on. You should really, and that's our situation. We've got, if anybody's scamming you, it's the damn banks. That's who you ought to be mad at, but you don't question and go after them the same way. But my point is, that's been our situation. We don't take in enough information. We're not fully doing our investigation on these companies or people or business or whatever to see what's what. We just hopping out there because it sound good. And that happens to anybody. You're going to get knocked over your head, man. Most people is scamming their relationships because they not who they say they are, right? They not who they say they are in that. They can put on this facade and then after so long of being with that person, it crumbles because they can't uphold that image that they tried to give you. So my point is, do enough investigation of yourself to see who is who, what's what. You know what I'm saying? Because I still always say there's nothing outside of me that has a right or accountability over me. That's me. I'm responsible for making decision if I trust you, if I actually thoroughly watch you, or did I just jump at something that looked like it was eye candy? It sounded good, and I jumped on it, and I went in there, and I got into class, and it wasn't what I thought it was. And then when I go back and start looking at it, I was like, yeah, I should have really paid attention. Like, that's my fault. Yeah. You see what I'm saying? So that's the type of people that I like to be around and who really fully take accountability. Now, I ain't justifying nothing for anybody out there that's scamming. If you're scamming, hey, it's going to catch up with you anyway. So it is what it is. But to what I know, man, y'all stay out the way, man. Keep your head in these books. Don't get caught up in none of the other shit. It don't matter. I don't care. People gonna love you. They're gonna hate you. They're gonna like you. They're gonna not like you. They're gonna like you again. It's just one of those things, man. And God gonna keep sending people to your life, and God gonna keep pulling people out your life. It is not the end of the world because another motherfucker said they don't like you. I promise. It's not. Straight up. So I appreciate y'all. I enjoy y'all. As always, y'all have a great and beautiful day. I will see you guys on Wednesday. Peace.
Peace, brother. Blessings.
Take care, Eric.
Thank you.
Peace out,
Take
man. Good
care.
shit.
All right, y'all. We'll see y'all TikTok. I see y'all tonight. I'll be on that night with y'all. So we'll see y'all later on tonight. We got something to talk about tonight. Peace.